I'm Shawna Brown, and I'm counsel here at Manzabaum Barrett in our elder law department. And it's always interesting when the kinds of cases that we handle come to life in the media. So recently, former talk show host Wendy Williams has been the subject of a lot of media attention. She's been in the news, the subject of a documentary, and she's been featured in certain interviews. And the focus of all this attention is the guardianship for Wendy. So a guardian was appointed in New York in court to make decisions for Wendy because the court declared her to be incapacitated, meaning that she can't make her own decisions and manage her affairs. Wendy claims she's not incapacitated, that she's being isolated, and that she feels like she's in prison and doesn't have access to talk to people she wants to or to use communication devices. This has created a lot of concern amongst her fans. Wendy is known for being really bold and brazen and outspoken, so it's a big change to see her appearing scared or vulnerable based on her prior persona. And a lot of her fans have initiated a Free Wendy movement, similar to the movement with Britney Spears a few years ago, who was also the subject of a guardianship in a different state. So Wendy's situation raises some questions. Even if someone has a guardian, can the guardian just absolutely tell them what to do? Does the person who's the subject of the guardianship have any say in anything? Can the guardian just lock them up and keep them from doing anything? These are questions that we often deal with. So Wendy has a guardian because she has a dementia diagnosis that has presumably proceeded to the degree that the court found that she can't make her own decisions anymore. Here at our firm, we often help clients with guardianships, and if they're successful, guardianships can allow our clients to help another person, often a loved one, make personal, medical, and financial decisions, which they can no longer make because they have a cognitive impairment or a cognitive disability. So the courts empower the guardian to make decisions for the other person. However, courts also aim to direct the least restrictive type of guardianship possible, meaning that the court can carve out certain areas where the ward, who's the subject of the guardianship, can still make their own decisions. So common examples would be retaining the right to vote or choosing your social and religious activities. And the takeaway is that guardians don't necessarily get to make every single teeny tiny decision depending on their ward's ability to participate in their own decision making or to at least consult with their ward as to what they want. Even if a guardianship is full, meaning that it allows for complete decision making by the guardian, courts in New Jersey still direct guardians, and New York does something similar as well, to consider what makes their ward unique and consider their likes, their dislikes, their hopes, and their fears. Guardians are also directed to encourage their ward to express preferences and participate in decision-making to the extent they can. Guardians are directed to give preferences often to expressed wishes and to promote their ward's right to privacy, dignity, and respect, and to maintain their self-direction and decision-making to the extent they can. So a guardianship is not putting someone in a bubble. People with guardians still have very vibrant, purposeful, and interesting lives. A lot of people who have guardians live independently or live with minimal supervision and just need some help, managing finances or managing their medical care. So Wendy's guardian appointed in New York is a court-appointed guardian, meaning that's an attorney from the community that the court asked to be her guardian. And that's a little challenging because it's not someone that Wendy had a prior relationship with. And the guardianship was sought initially by a bank that was concerned about Wendy's finances. So it's possible that the guardian is protecting Wendy from other influences in her life that they're afraid are trying to financially manipulate her. But if Wendy's able to express preferences, her guardian should be considering them if they're reasonable. For example, recently Wendy had asked to go see her father for his 94th birthday. And initially that was not permitted. And ultimately she did get approval to do that. So I think that's a good example of, I want to see my father and spend time with him. And as long as there's the proper procedure in place, that should be done. So that's an example of allowing a self-directed activity. Now, if someone is the subject of a guardianship and then they return to capacity, maybe their cognitive condition improves, they can seek to undo the guardianship. If they can establish through medical certifications that they can manage their affairs again and make their own decisions, It remains to be seen if Wendy can do this or is capable of it. I know that in the news very recently, it's been reported that her guardian is going to order a capacity exam for her. So we'll see what the outcome of that is. And it's an interesting story to follow, certainly, and to learn about how a guardianship works. So if you're seeking a guardianship or trying to help a loved one who is the subject of a guardianship and you have concerns, we can help guide you through that and through that process and determine the best steps to take to make sure your loved one is protected.